Well, you might have heard about it. I know we've mentioned it here on the news wrap. People in New York City will soon be required to show proof of COVID-19 vaccination for indoor activities like dining, fitness, and entertainment. Officials say the new policy is an effort to get the unvaccinated population to roll up their sleeves and get vaccinated. So far, about 55% of the city's population has been vaccinated. The new policy is set to be enforced starting September 13th and has raised many questions and concerns, whether this policy is even allowed, potentially even legal. So joining us now to discuss this is research scholar at Sandra Day O'Connor College of Law and Deputy Director at the West Region Office of the Network for Public Health Law, Jennifer Piatt. Jennifer, thank you so much for being here. We know this new policy definitely has a lot of people on both sides talking, some arguing whether it's inappropriate, others saying it's necessary. What are your thoughts here?
My thoughts are that this policy is grounded in the law. If we take a look back at Supreme Court cases addressing vaccination, the case that really set the standard is 1905's Jacobson versus Massachusetts. Now, this might seem like a long time ago, but it is still good law. It's still on the books today. And what that case said is that states have police powers, which enables them to regulate and legislate to protect the public's health. And that includes potentially mandating vaccination. In the Jacobson case, they were dealing with a smallpox vaccination. Here, we're dealing with a COVID-19 vaccination, but the reasoning is very much the same.
Could we see a challenge of that law, though, potentially here, right? Of those who are concerned about the impacts today. Is that potentially in the future at any time?
Absolutely. You can always expect litigation, particularly when a policy might be questioned, might be new. We have actually seen a series of cases that have been brought challenging COVID-19 vaccination mandates across the country so far. And we've had two decisions out of courts. One was out of a federal district of Texas court, and the other was out of a federal district of Indiana, which appealed to the Seventh Circuit. And in all of those cases that we've seen so far, courts have been upholding the mandates. So I think we could expect to continue to see that trend hold.
Kind of in the same vein, we know that's a video that's been circulating around Governor Cuomo, I think prior in this pandemic, talking about the vaccines cannot be mandated because they are under emergency use authorization. So how does that factor into what we know now?
Absolutely. So this was a legal question that started circulating around the country almost as soon as the vaccines were gearing up to be authorized via emergency use authorization rather than a full biologics license. And the questions revolve around this specific language in the Federal Food, Drug, and Cosmetic Act. And that language says that the Secretary of the Health and Human Services can set conditions on individuals receiving information about the vaccination, including their right to refuse or accept the vaccination. And so a lot of arguments have been put out there that language prevents mandating the vaccine. But in the court cases we've seen so far, and in a very recent opinion issued by the Department of Justice's Office of Legal Counsel, the actual analysis demonstrates that language does not prevent mandates. All it really does is set conditions on the Secretary of Health and Human Services and set conditions for information that needs to be provided to people. It doesn't affect whether you can mandate those vaccines or not.
In addition to kind of the mandates that we're seeing right now, particularly here in New York, we know that New York has that Excelsior pass. It's on this NYC COVID safe site. Are there any additional concerns with privacy when it comes to kind of these vaccine passports and then these apps that are being created, at least here in New York, and that could potentially kind of be created in other parts of the country and other cities and states? Does that add a layer of complication here, at least certainly along the privacy lines?
So with respect to the privacy question, there's always the ability for people who are concerned about this to use their paper card as verification and to not use the application. What we've seen from the Excelsior, the New York State website addressing the Excelsior Pass, it states that it's not tracking your movements. There's very explicit language in their privacy policy, and the COVID Safe app is actually basically an app that allows you to take a picture of your COVID-19 vaccination card. And so it doesn't communicate with state registries or government registries. There's no kind of communication, so no real privacy issues there. One other thing that I would like to address is HIPAA. So we've heard a lot of arguments regarding the HIPAA preventing anybody from asking about your vaccination status. That's not correct. So HIPAA's privacy rule, what it does is it actually prevents your or my or anybody's healthcare provider from going and sharing a patient's personal healthcare information. So my provider couldn't go and share my protected health information with someone else. But HIPAA has nothing to do with whether I share my own health information or whether other people ask about it.
Yeah, it's so interesting you bring up that point because HIPAA is one of those things that people get wrong so often, and great for you to kind of bring it up and hone in on it there. It relates to your doctors releasing information, not about an establishment asking for that information. Thank you so much for providing more context and insight. This is a talker for a lot of people right now. Jennifer Piatt, research scholar and deputy director at the Western Region Office of the Network for Public Health Law. Thank you so much.